I studied contract law basics. In contract law, consideration is something of value that is exchanged between the parties. For a contract to be valid and enforceable, there must be consideration from both sides. Each party must give up something, for example, money, services, or a promise, or commit in exchange for the other party's promise. Regarding this week's case study, I learned that summary judgment is a U.S. law proceedings. In a U.S. law proceeding is a legal procedure used to resolve a case without a full trial when there is no genuine dispute about the key facts of the case. It allows the court to decide the case based on the law because the essential facts are agreed upon or uncontested. As personal takeaways, I did not understand at first about stare decisis, but after research, I got the meaning clearly, that it means to stand by the things decided. In simple terms, it refers to courts adhering to precedent or previously decided cases when making rulings in new cases involving similar issues or facts. It promotes consistency and predictability in the law by ensuring that courts follow established legal principles unless there is a compelling reason to overturn them. As a nature of contract is a set of legally binding promises. You may enter into thousands of agreements throughout your life, but not all those agreements will be considered contracts. Only enforceable agreements are contract. There are three elements of contract: offer, acceptance, and consideration. The offer is a key component of the contract and consists of the terms and conditions set by the offerer and offeree. Acceptance is the agreement of the offeree to the terms of the offer. Consideration is what each party gets in exchange for completing the responsibilities under the agreements. There are different types of contracts. First is bilateral versus unilateral contract. If the offeree can accept by promising to perform, the contract is bilateral. The contract comes into existence once each party commits to the deal. Unilateral contract differs in that the offer can only be accepted by the performance. Express versus implied contract. In an express contract, the terms of the agreement are fully and explicitly stated in words or oral or written. A contract that is implied from the conduct of the parties is called an implied contract. Courts will find an implied contract if the following elements are met. The plaintiff provided some service or property. The plaintiff expected to be paid for that service or property. The defendant knew or should have known that payment was expected. The defendant had an opportunity to reject services or property and did not. Offers is for the offer to be valid offer, it must be a serious offer. The terms must be relatively certain and it must be communicated. To determine whether the offer was serious, determine whether or not a reasonable person would consider that the offer was legitimate. In general, the contract must include the identities of the parties, the subject matter of the contract, and the consideration to be paid. Termination of the offer, revocation, one of the termination of the offer, which occurs when the offeror takes back the offer before the offeree accepts. It also occurs when the offeror takes back the offer either through communication or any act that is inconsistent with the offer that is also communicated to the offeree. Termination by actions of the offeree is that if the offeree rejects the offer terminates. An offer simply can stay open forever. Offers only remain open for a reasonable amount of time. And if the subject matter of the contract is destroyed, then the offer is automatically terminated. Consideration is the value each party receives in return for entering the contract. And consideration may consist of a promise to do something that one party has no duty to do, the performance of an action that one party is not obliged to perform, refraining from doing something that one party has the right to undertake. Courts will not enforce a contract if the consideration is for actions or events that already happened or promises that are illusory. This is the summary of the contract law. Thank you.